Welcome. I'm Kerry Colanisi, the director of the Penn program on regulation, and I'm delighted to have you join us for today's lecture. This is the Penn program on regulation's 15th anniversary year, and today's lecture is the 10th in our annual Distinguished Lecture Series. This lecture series began originally as part of a year-end dinner to celebrate the achievements of the regulatory review and all of the Penn Law students who are involved in publishing the review, which is a daily online publication sponsored by the Penn program on regulation. Due to the COVID conditions, we shifted last year and again this year to an online format for the lecture. Nevertheless, I see this as an occasion at which I want to acknowledge and thank all the amazing students who are involved in producing the regulatory review. It takes a tremendous amount of time, effort, talent to write and edit and publish new content every Monday through Saturday without interruption. And today's student writers and editors on the regulatory review continue to build on the excellent work of their predecessors. So I want to acknowledge and offer a special thanks to all of them for today on this occasion of our 10th lecture. Special thanks go to our current editor-in-chief, Jocelyn Walcott, and our managing editor, Richard DiNapoli, for their many tireless efforts in leading the publication so well this year. Let me now turn to today's lecture, which focuses on a vital area of regulation that we have yet to address in our preceding distinguished lectures. That is the regulation that governs voting. It's fitting, of course, that we're holding today's lecture on Election Day in the United States, as this provides an apt reminder of the vital need for public engagement by all members of society to make democracy work. Today's lecture is also part of Public Interest Week at the University of Pennsylvania Law School, organized by the school's Toll Public Interest Center. As the lecture is also part of the Penn program on regulation's year-long lecture series on race and regulation, it is also co-sponsored by Penn Law's Office of Equity and Inclusion. And surely no domain for equity and inclusion is so fundamental to a just society than in the democratic process. For that reason, I am exceedingly excited and honored to welcome you to today's lecture and to introduce our lecturer, Guy Charles, who will help illuminate for us the challenges ahead in the law and politics of election regulation. Professor Charles is the Charles J. Ogletree Jr. Professor of Law at Harvard Law School, where he also directs the Charles Hamilton Houston Institute for Race and Justice. A graduate of the University of Michigan Law School, go Blue, he has served in the past on the law school faculties at Duke University and the University of Minnesota, the latter where he was also an interim dean. Professor Charles is currently a member of the Presidential Commission on the Supreme Court of the United States. A prolific scholar, he is the co-author of Racial Justice and the Law, Cases and Materials, and he is co-editor of Race, Reform, and Regulation of the Electoral Process, Recurring Puzzles in American Democracy. He's currently collaborating on yet another book on voting rights and the Voting Rights Act, from which I'm sure some of the ideas he presents today will draw. So please join me in welcoming Professor Guy Charles for his lecture, Race, Power, and American Democracy, Rethinking Voting Rights Law and Policy for a Divided Nation.
Thank you so much, Kerry. It is my pleasure to participate in this lecture and my distinctive honor. Also take an opportunity to thank you for your friendship and this wonderful invitation and to deliver this lecture. I'm very grateful for it. This is a wonderful program, and I want to greet my friends at the University of Pennsylvania Law School. I regret that I can't be with you in person, but I am grateful that you have joined me this afternoon to help us think through the relationship between race, or the relationship really among race, political power, and American democracy. And this afternoon, I want to explore that relationship and really advance two premises. One major premise. The first is that structural political inequality and structural racial inequality are mutually reinforcing, and that we can't solve racial discrimination in voting without a vigorous commitment to resolving political inequality, as well as vice versa, that our commitment to political equality must also include a commitment to eradicating racial discrimination in voting. I will also advance a minor premise, which is that our commitment to political equality must be centralized, nationalized, and taken away from the states. That is, where we agree that there are certain sets of practices that advance political equality, and that there are certain sets of practices that undermine political equality, we should preclude the states from enacting those sets of practices, and we should nationalize those practices. I will illustrate both premises through an old constitutional case, and I will also use the case to map out the possibilities for thinking about how to deal with racial discrimination. And then I will conclude with offering the Freedom to Vote Act as a good example of where we ought to go from here. All right, so let us now begin. Fred D. Gray stood before the justices of the Supreme Court of the United States on October 18, 1960, to show them a giant map. Gray was only 30 years old at the time, but he was already then a noted civil rights lawyer and preacher. A native of Montgomery, Alabama, he attended the law school in Ohio because no other law school in Alabama would admit Black people. When he faced the court on that Tuesday afternoon as co-counsel in the gerrymandering case of Gamillion versus Lightfoot, which is familiar to a lot of you, I'm sure, this young Black civil rights lawyer was nevertheless an experienced hand in making the legal case against the hegemonic regime of the Jim Crow South and its idiosyncratic brand of racial discrimination. Gray, along with Charles Langford, Robert Carter, they were the lawyers for the civil rights activists in Gale versus Browder, which challenged Montgomery's Jim Crow's bus system, and the challenges prevailed before a 3-judge trial court. In a rebuke to Alabama, the Supreme Court summarily affirmed the judgment by issuing a 1-sentence order citing Brown v. Board. Without having to say much, the court sent a very clear message that Plessy was no longer the law of the land. Now, Gray confronted a very different problem in Gamillion than the one presented in Gale versus Browder. In Gale, he simply had to get the judges to apply the principles of Brown versus Board to the context of public accommodations. Both the law and the facts were on his side in that case. Alabama's law permitting racial discrimination in public accommodation was clearly inconsistent with Brown, and the racial discrimination there was undeniably evident on the face of the statute. A law that required racial segregation was racial discrimination. By contrast, though, Gamillion posed an epistemic challenge for Gray and his team. They had to prove that the redrawing of the boundaries of Tuskegee was a racial gerrymander, that is, a segregation of the races, and not a political gerrymander or simply a remapping of the municipal boundaries. A racial gerrymander, of course, would have been unconstitutional, but a political gerrymander, or change simply in the municipal boundaries, was within the sovereign power of the state, as under the law of the time. So unlike Gale, in which the evidence of racial discrimination was evident on the face of the statute in Gamillion did not say anything about race, or really anything other than latitude and longitude. And I might say a few words about that in a moment. Now, there was no doubt about the fact that the remapping of Tuskegee was a blatant racial gerrymander. Sam Engelhardt, the state senator who authored the statute in the Alabama legislature, was crystal clear about the statute's purpose. He said to exclude colored voters who might become the balance of power in Tuskegee city elections. According to the existing legal doctrine of the time, the state's motivation, which did not appear on the face of the statute, was not a relevant consideration for ascertaining the constitutionality of the statute. So unless the plaintiffs could convince a court and the Supreme Court to take motive into account, or that the redrawing of the lines was a racial gerrymander, the Supreme Court would defer, as did, and here's a preview of both the district court and the appellate court, and Gamillion did. They would defer to the state's assertion of its sovereignty to structure its political system as it saw fit. And the state argued, we have a right to implement our conception of political equality. And as long as we're not expressly engaged in racial discrimination, that right ought to be respected. Now, though Gray did not have much in the way of admissible evidence, he did have a map. The map illustrated literally the egregiousness of the state's racial discrimination. Look at the map, Gray urged the justices. The lines of the map represented how Alabama removed almost every single registered Black voter from the city of Tuskegee, but not a single white person, much less white voter. It was clear from the jagged lines of the map that this was not a normal redrawing of the municipal boundaries. The state's exclusionary purpose in the effect, Gray stated to the justices, is revealed by the map. The challenge for the plaintiff's lawyers in Gamillion was getting around the state's reliance on the theory of state sovereignty. And that theory shielded the state's voting discrimination against their Black citizens. Gray and his colleagues were hoping to build upon a set of cases in which the court refused to defer to the state's supposed sovereign prerogative to structure its political system as it saw fit, where the court believed that the state's electoral or voting rules was racially discriminatory. Without the aid of Congress, the court had attempted, so these were the white primary cases as an example, with mixed success to curb the South's strong appetite for racial subordination. Sam Engelhardt, the senator that I mentioned before, was a member of the White Citizens Council. And obviously he was responsible for this statute. The language of the statute, though, stated that the purpose was to alter, rearrange, or redefine the boundaries of the city of Tuskegee. The statute didn't simply change the boundaries, it also removed a lot of the Black citizens, all right, every single one, but 4 or 5 Black registered voters. And prior to being drawn, as the court mentioned, the city was a squarely shaped town with about 6,700 or so residents, 5,300 or so of whom were Black and about 1,300 were white. It had 1,000 registered voters, 400 of whom were Black and 600 were white. After being redrawn, it was now a much smaller 28-sided town. So Gray filed a class action on behalf of 12 of the city's residents, including some of its most prominent citizens. And their factual allegations were straightforward, that Alabama redrew the Tuskegee for the express purpose of preventing the city's Black residents from acquiring political power and denying them the right to vote in the city in violation of the 14th and 15th Amendments. That is the only reason Alabama redrew or created a new Tuskegee is because he wanted to remove Black people from the city as they were poised to gain political power in the city. So in his complaint on behalf of the plaintiffs, Gray cited Engelhardt's statement that the purpose of the statute was to prevent Black people from gaining political power, because Engelhardt was not shy about his views. In fact, gave some interviews to newspapers stating what he thought what the purpose of the statute was. And if the court struck down the statute, Engelhardt told the press that Macon County and Tuskegee would be the first to fall under the control, in his words, of Negroes. Now, in contrast to the factual allegations, the plaintiff's legal argument were not quite as straightforward. The court had decided Gamillion 6 years after, or faced Gamillion 6 years after Brown won, which means that the legal framework was Brown's conception of formal equality, as opposed to that, of course, of Plessy versus Ferguson. And Brown's articulation of constitutional equality was inarguably beneficial to Black people subject to Jim Crow discrimination. However, the new legal framework also made it possible for the government to shield its discrimination under the cloak of neutrality. So unlike the school desegregation cases, or cases in which the government used an explicit racial classification, here, the act did not use an explicit racial classification. And in fact, the act said nothing about race at all. The statute on his face was a redistricting statute. As Sandra Day O'Connor would observe about 30 years later in Shaw versus Reno, which was a case about the constitutionality of Section 2 of the Voting Rights Act, a reapportionment statute typically does not classify persons at all. It classifies tracts of land or addresses. So the substantive content of Act 140, this redistricting statute, consisted of a series of instructions on the new municipal lines of the reconstructed city. So the act provided that the new city would begin at the northwest corner of Section 30, Township 17N, Range 24E, and Macon County, Alabama, then would proceed south 89 degrees, 53 minutes east, 111 feet, then south 37 degrees, 34 minutes east, and continued that way until it mapped out the full lines of the new city. So Alabama could and did plead both race neutrality and state sovereignty. They argued that the redrawing of the city was just that. It was a map that drew new boundaries of a subsidiary of the state, not a statute that separated the races on its face, and then altering the configurations of a political or municipal boundaries was wholly within the power of the state. We have the right to draw our municipal lines and to determine who belongs and who ought to have political authority per our state sovereignty, right? And Alabama argued under existing law that the motives of the legislature, much less that of a single senator, was not at all relevant. Motives were not relevant in assessing the constitutionality of the statute. So, and then lastly, Alabama argued that lawsuits about political boundaries were non-justiciable political questions. They raised questions about the federal courts, that the federal courts did not have power to decide. Right, we can begin to see the contours of the modern framework here in this case of Gamillion versus Lightfoot, right? That we have a question of racial inequality coupled with political inequality, with the state getting to say, look, we have the sovereign power to determine our political boundaries, and whatever we do on the political inequality front, it doesn't matter to the federal constitution. I'll come back to this point in a moment, but let me just make one final observation here. It did not take any imagination to figure out what Alabama was up to. Everyone knew what the state was doing and that it was doing all that it could to prevent Black people from being able to register and to vote. Tuskegee and Macon County were both racial oligarchies. The majority population in Tuskegee and Macon County were Black, outnumbering whites. Black people outnumbered whites 5-1 in Tuskegee and 6-1 in Macon County. But white people held all the political power. There were no Black elected officials at any levels in the city or county. And in fact, Bernard Tapper in his book on Gamillion relayed the indignation and shock of local white residents when a Black woman, Jessie Guzman, director of the Department of Research and Records at the Tuskegee Institute, ran for a seat on the Macon County School Board. Right? So they were sort of indignant that a Black person would dare run for election. The fact that all knew that states like Alabama were practicing gross racial discrimination did not mean that the courts would be solicitous to cries for redress by Black plaintiffs or their allies. A year or so after Fred Gray filed his lawsuit on behalf of Gamillion, C.G. Gamillion, and other Black residents, the Justice Department unsuccessfully sued the state of Alabama, the Registration Board of Macon County, in which Tuskegee was located, and then 2 other former county board of registrars. The department's suit was based on the remedies provided by the then new Civil Rights Act of 1957. The department accused the defendants of engaging in the usual discriminatory practices, separate and segregated registration facilities, discriminatory application of literacy tests and registration requirements. The department also accused the defendants of periodically failing to staff the county board of registration to make it difficult, if not impossible, for Black voters to even attempt to register to vote. The department lost, and United States versus Alabama panel of the Fifth Circuit Court of Appeals, which included Judge Warren Jones, who would later author the Court of Appeals decision in Gamillion, upheld the dismissal of the department's lawsuit. The appellate court agreed with the lower court that the 1957 Act did not authorize the federal government to sue a state, that the act did not authorize the government to sue the board, and that the government could sue the individual, could not sue the individual registrars because they were no longer registrars, they had resigned. And the court concluded its analysis with a familiar refrain in this context. The remedy does not lie in perverting jurisdictional processes by means and to ends as injudicious as they are unjudicial by holding one who is not an officer responsible as such. Rather, it lies in taking appropriate action under Alabama law to compel those authorized to and responsible for constituting and filling vacancies in the membership of the board to fill those vacancies. This is an incredulous statement, and I'll come back to that in a moment. Now, despite the failure of the challenge of the state's electoral laws in the United States versus Alabama, that is, Alabama prevailed. What is interesting is that the state's Hydra-like discriminatory practices that were at issue in the case were necessary, though they weren't sufficient to prevent Black residents from acquiring political power. Whites in the South viewed Black political power as an ever-present threat. This was particularly true in jurisdictions where the Black population overwhelmed the white one, and where the legal framework, and here Brown's incipient equality frame, and the timid but stalwart Civil Rights Act of 1957 provided some, even if weak, oversight of the state's discriminatory practices. So for example, where Black residents in Tuskegee exceeded white residents by 5-1, the Black community needed only a couple hundred more Black registered voters before they could take control of the city. And Alabama's primary device of denying Black people the ability to register and vote, that is a discriminatory application of its literacy test, was on borrowed time in Tuskegee as well as in Macon County. Tuskegee was home to what I'm sure all of you know was then called the Tuskegee Institute, now Tuskegee University, and at the time was one of the most prestigious historically Black colleges in the country. Tuskegee was also home to the Black Veterans Hospital that boasted some of the leading Black doctors and medical professionals in the country. Though a significant percentage of Tuskegee's and Macon County's Black residents were poor and uneducated, because like Alabama, like other states in the South, simply did not care for its Black citizens, some of Tuskegee's Black residents were also some of the most educated in the South. And by 1950, by the mid-1950s, they were also some of the most agentic. Booker T. Washington, who founded the Institute, had developed an accommodationist ethic in dealing with white leaders, which allowed Tuskegee a certain amount of flexibility and created a very strong Black middle class. In return, though, Washington accepted a second-class political citizenship, at least for some, though probably not so much so for Washington. And the assumption of his accommodationist approach was that economic independence and flourishing of Black people would eventually bring about social and political equality, specifically for the Black elites. But unfortunately, and to the dismay of the Black political elites, Washington's approach failed to live up to its promise. White city leaders, with rare exceptions, did not differentiate between the Black political elites and the Black masses. And so they treated Black political elites like second-class citizens, notwithstanding the fact that some of them were better educated and wealthier than their white neighbors. But they posed an ever-present threat. Right? Black political elites in Tuskegee were relentless in their quest to obtain the right to vote in the city. They also seriously worked with less educated Black registrants to make it harder for the registrar to reject their applications on mere technicalities, a favorite tool of the registrars. Therefore, eligible Black voters would, over time, eventually make up the registration gap between white and Black registrants. Moreover, the pool of potential Black registrants was simply too numerous and the white population too small. And the law, though feeble, was nevertheless a present sentinel. So it was no longer possible for the registrars to discriminate continuously against every single Black voter, which is what they would have to do in order to maintain their political hierarchy. And something similar could be said about the periodic disbanding of the Board of Registrars. It was necessary to the state's disenfranchising scheme, but it wasn't sufficient. Eventually, white people would need to register as well. And given Tuskegee's Black community's sense of efficacy and agency, as well as the post-Brown constitutional regime, it was going to be hard to open registration to white people while denying it every single time to Black people, though they did try. The city leaders did try to do that. When the Board of Registrars met, it met sometimes in secret so that it could register white citizens and white citizens only, right? So there's a story in Robert Novell's book that relays how a Black activist in Tuskegee sent in a white passing Black resident to find out where the board was meeting and to alert the city's Black residents. Now, disenfranchising Black voters also required absolute solidarity among the white community. And every once in a while, a white person would defect, as happened in Tuskegee as well. So Sam Engelhardt viewed the Black community as an ever-present threat to white political power, and anticipated that eventually something more would need to be done. He had long advocated the ingenious plan of removing the Black residents from the city by redrawing the boundaries of the town. He argued that gerrymandering would be an effective way of dealing with incipient Black political power because the courts would defer to the right of the state to draw the boundaries of its municipalities as it wanted. Engelhardt's scheme was not just restricted to Tuskegee, by the way. State leaders were preparing to do the same in Macon County, Alabama. And in fact, Alabama had amended its constitution to give the legislature the option of abolishing Macon County or reducing its area. Right? Presumably, this is a strategy that could be replicated across the state and across the region. So here's the point that I want to make. Gamillion vividly presents the symbiotic relationship between structural political inequality and structural racial inequality. Alabama's plan to remove the Black residents from Tuskegee and ultimately from Macon County was possible and sensible only because the Constitution allowed the states to create unequal political units. Or to put it more precisely, or to put the point less passively, Alabama could contemplate gerrymandering Black citizens out of Macon County because the court did not interpret the Constitution to require the states to create political units that weighed votes equally. The court allowed the states to engage in a political oligarchy. Alabama was then subject to two different regulatory regimes, one of which allowed it to do whatever it wanted to do with respect to the citizens and its political units, and the other of which required it to grant its citizens equal suffrage rights on the basis of race, one in which it was regulated and the other in which it was unregulated. Correspondingly, Black citizens were also subjected to two different types of legal regimes. If they were categorized on the basis of their race, they were entitled to equal suffrage rights. But if they were categorized by geography or by political unit or by political party, they were then treated unequally. These different regulatory regimes present Alabama with an arbitrage opportunity. If the constitutional system was going to prevent Alabama from denying suffrage rights to Black people, but it was not going to prevent Alabama from favoring one set of political units over another, Alabama could still achieve its racially discriminatory aims, that is, suppress the voting rights of its Black citizens, by placing them in disfavored political units. Alabama simply needed to convince the federal courts that the Constitution respected the state's plenary rights to redefine the boundaries of its sub-state jurisdiction as it saw fit. This is a non-justiciable political question. And notwithstanding the discriminatory effects, and maybe even the discriminatory purpose, right, the state had the sovereign power to do as it wanted to. But differently, Alabama simply had to convince the federal courts that the state had the right to elect between two different regulatory regimes. And so long as Alabama could shield its racism behind the veil of state sovereignty, notwithstanding what everyone knew that was going on, Alabama could maintain its racial and its political oligarchy. Right? And the point is that racial oligarchy and political oligarchy are intertwined, and that it's hard to have one without the other. And here the question simply in Gamillion was whether the federal courts were willing to go along. And they almost did. Gamillion demonstrates the challenge posed to plaintiffs bringing voting equality claims by the legal system's default presumption of plenary and legitimate state power. This is a challenge that would seem to favor the state in part because the legal regime saw state authority as presumptively legitimate. And in many respects, we still do. When the state regulates on the basis of its authority to structure its political process, we simply defer. And in part because the claim of racial discrimination in Gamillion raised some, if not significant, epistemic uncertainties, the questions were very complicated, and they still are today, right? Is a voter ID a racially discriminatory device, or is it simply the state deciding for itself what it wants to do with respect to its political system? Gamillion arose in the post-Brown legal context, where there was very little doubt that the court would enforce the Constitution's prohibition against racial discrimination when the discrimination was evident on the face of the statute. But it was concomitantly less clear what the court would do when racial discrimination was not so evident. Gamillion thus presented a direct confrontation between assertions of state power and racial equality. Now, Gamillion was not just a race case, it was a voting case as well, right? That is, adding to the complexity of the case, the voting question here was conceptually mushy. On the one hand, one could characterize the constitutional claims in Gamillion as vote denial claims, that is, the deprivation of suffrage rights on the basis of race, and if so characterized, the decisions in, say, the white primary cases left no doubt that the court would vindicate representational rights under those circumstances. On the other hand, one could characterize the representational claims as dilution claims, that is, claims about relative voting power on the basis of group identity brought about by the design of representational structures. And if so characterized, the court's decision in Colgrove versus Green, a malapportionment case, made clear that the court would not vindicate other types of representational claims that were primarily about the composition of electoral structures or structures of representation. So Gamillion presented a multifaceted puzzle that has long and continues to bedevil and trouble the court's race, politics, and law jurisprudence. How should constitutional law respond to the intersection of structural, racial, and political inequality? The court's law and politics jurisprudence has generally offered four approaches when confronted with structural, political, and racial subordination. The first approach is pure and unquestioned deference to the supposed sovereign right of the state to determine its voting rules and arrange its electoral institutions in whatever manner that is consistent with the state's values. Right? This total deference approach rarely acknowledges either the racial inequality or the political inequality. The second response is to acknowledge the racial inequality, but nevertheless defer to the state on plenary powers grounds. A third approach is deference to the state on the theory that the race claim is at bottom a claim about political power and therefore indistinguishable from a claim of unequal political power. And then lastly, there's the approach of race exceptionalism, which is the argument that racial discrimination is an exception to the state's plenary powers. You can do whatever you want and we'll defer to you, except where you are engaged in racial discrimination. There's a fifth possibility, and the one that I will close with, which is one that rarely finds support in the court, but this is an approach that concedes that structural racial inequality and political oligarchy are mutually symbiotic. Both types of inequality benefit from each other, and the harm caused by one is compounded by the other. Because the harms caused by both types are compounded by their co-occurrence, they both ought to be regulated either through congressional oversight or judicial oversight. Right? And that, I think, is where what I would recommend and where I would end. So unsurprisingly, Gamillion generated a number of different opinions. Judge Frank Johnson, who was a renowned federal civil rights district court judge, basically took the total deference to state sovereignty approach. The opinion didn't say anything about race. He did not address the racial inequality claim. He simply said, look, the state has a right to create whatever structure that it wants, and that the Constitution has nothing to say about it. The closest he came to addressing the racial discrimination claim was when he obliquely rejected the plaintiff's charge that racial discrimination explained the revised lines in Tuskegee. Faced with the claim of racial discrimination, the district court pled helplessness. He basically said, this court must now conclude, presumably he was sad about it, that regardless of the motive of the legislature of the state of Alabama, regardless of the effect, and so far as these plaintiffs' right to vote in municipal elections is concerned, this court has no authority to declare said act invalid, right? So meaning there's nothing that the court can do. Of course, it is hard for to understand how Judge Johnson can conclude that this court has no authority. And he then went on to say that this court has no control over, no supervision, no power to change anything. The only thing that the plaintiffs could do is go to the people of Alabama and to ask for redress, right? So this is an incredulous conclusion when Alabama was in the process of depriving the majority of its Black citizens of suffrage rights, but that's the full sovereignty point. Then we have the state sovereignty, though taking the racial discrimination into account. This is when the plaintiffs went up to the Fifth Circuit, an opinion that was authored by Judge Jones, and in which Judge Jones essentially said, look, the Constitution defers to the state here. He cited the leading treatise of the day, and the only concession he acknowledged that it was a racial discrimination problem, but really the only concession that he was willing to make was to say, well, look, where the general obligation there are certain sets of circumstances where the state has an obligation, we can intervene, but this is not one of them. And that the courts will refrain from making any inquiry into the motives of the legislature. We won't be influenced by any opinions of any members of the legislature, any committees, or any other person. So he acknowledged that this was a claim of racial discrimination, but simply said that there is nothing that the courts can do. Then we have two other views, which is that, look, judicial review is possible, but only under a certain set of circumstances. And this is the view that we saw from Judge Minor Wisdom. So Judge Minor Wisdom agreed with the majority opinion in the case and said, look, this raises a grave problem, but it's non-justiciable because the race claim is the same as the politics claim. Right? So recognizing that this is a racial discrimination problem, but it also raises a political equality problem. But because it raises a political equality problem, we have to defer. And then finally, there's a dissent in the case from Judge Brown, and Judge Brown's argument was, we have to take the claim of racial discrimination seriously, that the claim of minority rights, that what Alabama is doing to its Black citizens is a violation of the Constitution, and that the judiciary is not prohibited from ascertaining legislative purpose, and that the judiciary has a role to play in vindicating racial and political rights. Right, so here we have an outline of the framework, and then this case goes up to the Supreme Court, and the court then decides on race exceptionalism grounds that racial discrimination is a violation of the Constitution, even where the state has the right to structure its political framework, its electoral institutions, in a manner that it sees fit. All right, so from my perspective, Gamillion then creates presents a strong question for how we ought to think about this relationship and the structure between political equality and racial inequality, with the court taking the race exceptionalism approach. Gamillion also leads to the Voting Rights Act of 1965. The court wouldn't take another voting rights case after Gamillion until South Carolina versus Katzenbach, but Gamillion sent a clear message to the lower court, but it also provided a framework to think about the VRA. Right? The VRA was influenced by this idea that, yes, political equality and racial inequality are intertwined, but also where race is at issue, where racial discrimination is at issue, Congress has the full power to step in and to intervene and to provide oversight. So for 50 years, the VRA provided the regulatory framework and placed the question of voting inequality at its center. It was, even though the 15th Amendment was nominally the fundamental law of the land, but the VRA really is what gave promise and life to the 15th and the 14th Amendment. And though the story need not be retold, the VRA fulfilled on the promises of the 15th Amendment, began to deliver on the guarantees of self-rule that was implicit under the 14th Amendment, and brought the South into the fold of representative democracy, but also signaled to the nation that a new era of both racial and political equality was at hand. Now, we know that that regime ended in 2013 with the Supreme Court's decision in Shelby County versus Alabama, in which the court struck down Section 4B of the Act, the provision that identified the jurisdictions required to obtain preclearance, and then sidelined Section 5 of the Act, the provision that actually required preclearance, right? Section 5 of the Act said, okay, if you're subject to Section 4, you have to preclear changes related to voting. The court's decision in Shelby County, though it did not come as a surprise to voting rights experts, but ended a regulatory framework in which racial discrimination was placed front and center in the regulatory firmament. From the court's perspective, the act violated the conceptions of both state sovereignty and equal state sovereignty, the same set of ideas that we saw rejected in Gamillion versus Lightfoot. Shelby County effectively ended the regulatory regime, and we are now in its aftermath. And the question then, where ought we go from here? Some quick lessons, and then I will close. The VRA represented the relationship among Black agency, democratic politics, and constitutional law. Black activists using the VRA sought to remake the racial order, but they also sought to remake the political order. A protest movement changed not only politics, but it also changed constitutional law. The task in the post-VRA world is to take the lessons that we've learned from the regulatory regime of the VRA, that there is a strong relationship between racial hierarchy and political oligarchy, and that we need to think through how do we make both? And how do we make both through a protest movement? And how do we make both through constitutional law? So the fundamental task, I will argue, for American democracy today is to create an inclusive political order, an inclusive order that includes everyone, in which fundamentally our political and constitutional structure takes seriously the right to vote and assures that that right is not undermined for any group, whether it's on the basis of race, whether it's on the basis of ideology, whether it's on the basis of geography. The future of voting rights policy should focus on developing a new political as well as legal consensus in which voting is regarded as a universal and fundamental right, and which is made available to all. That conceptions of state sovereignty have no role to play, that the state cannot elect between a regulatory regime that says, if you effectively discriminate on the basis of race and we can prove it, we will stop you from doing so. But if it's simply on the basis of politics or political ideology, notwithstanding the fact that these two things can be interrelated and that you can arbitrage between them, we're not going to say anything about it. We should not allow the government to regulate access to the franchise and not make the franchise effective, right? The franchise should be effective, and it should not be, the government should not be allowed to change voting rules that make it harder for citizens to vote on the basis of racial, partisan, or other types of ideological grounds, or impose other barriers to political participation. What does this new world look like? And now I will close. This new world looks like two statutes, and here I'll focus on one, the For the People Act or the Freedom to Vote Act. If you take the Freedom to Vote Act and its provisions, it takes voting seriously as a fundamental right. It attempts to articulate our best practices and to nationalize those practices. It undermines the conception of state sovereignty, that the state has the right to create its political structure as it sees fit. It recognizes that the right to vote belongs to citizens, so it makes certain sets of practices like early voting, mail voting, no excuse absentee balloting, preventing partisan gerrymandering, providing remedies for vote certification, modernizing voter registration. It takes some of our best practices, nationalizes them, and recognizes that the fundamental point here is to make voting and political participation an important aspect of democracy. If we are to move forward in this part of the 21st century, we must recognize that the relationship between political equality and racial equality are mutually reinforcing, and that we cannot have one without the other, that we need to build a new movement, a movement that ought to be worthy of the civil rights movement that led to the 1965 Civil Rights Act, and that is really up to us to make that determination. And it is up to us to move the ball forward. And on this election day, to make political power and representative democracy true for everyone and for all of us. I will pause here for your questions. Thank you.
Thank you very much, Professor Charles, for that analysis and inspiration for where we need to go. I would invite any member of the audience who's interested in asking a question of Professor Charles to type that in the Q&A function at the bottom of your Zoom screen. And in the time that's remaining, I'll try to get to as many of those questions as we possibly can. Professor Charles, if I can start perhaps by way of a clarifying question, but also invite you to help us see what the possible future moves might be for the kind of movement that you've called for at the end. Would it be fair to say that, following your, analysis of Gamillion and your articulation of the various approaches that the law took or the judges took in that case, that we're in a situation now where largely the law is back in the total deference category, both certainly on gerrymandering, but also on racial equality in the voting arena. And combine that with the fact that the legislation that might be warranted at the federal level, we know is not going to make it through the Senate. So, are we at really at a very much of a dead end, right? At least in the short term, for achieving the kinds of egalitarian goals and inclusiveness that you were articulating?
Yes and no. So the first thing to think about is the 65 Act was the third or fourth try by Congress to get a robust statute enacted and to deal with the problem of racial inequality. And if we were looking at the world and say the 1930s, or if we're looking at the world in the 1940s, and maybe even after 1957, and looking at the failures and the way that the 57 Act was gutted essentially, and the strongest provisions taken out, we might have had a relatively pessimistic view about what the future would look like. And in some respects, it would have been justified, right? Not knowing that just a few more years down the road, we would get the most transformative statute, arguably the most transformative statute that Congress has ever enacted. Some have made that point, and I certainly believe it. And so looking at the current moment in which we find ourselves, I think there's reason to be pessimistic, that we see that there's a fairly strong partisan divide across our institutions. So we have, as you mentioned, a deregulatory framework from the court on both race, right? You see what the court did with Shelby County, but you could also look and see what the court did in the recent Bronovich case with respect to Section 2 of the Voting Rights Act. The writing seems to be on the wall on that side as to deregulation, and of course, as you mentioned, the political gerrymandering cases. We're looking at Congress and we're seeing very little action, and maybe if we're lucky, we might get something on the John Lewis Act, right, which is an attempt to revitalize the Voting Rights Act. So if we're really, really lucky, maybe that might happen. But we see a world in which we are extremely divided, and that some of the states are engaged in discrimination on the basis of voting, some of which is on the basis of partisanship, some of which is on the basis of race, some of which is a combination of the two. We're looking at what is going on in terms of gerrymandering and redistricting, racial gerrymandering and redistricting in a deregulatory world, right? So there are reasons to be pessimistic. But on the other hand, for the first time in a very long time, there is a strong segment of the population that wants to take not just voting equality questions, but questions of electoral structures, right? The Electoral College, the composition of the Senate, different ways of organizing alternative voting systems, want to put all of these questions and issues on the table. We have lots of places in which we have same-day registration, early voting, right? We've implemented ways of making it easier for people to participate. So the question is, so if we're looking at where we are today, I think, yes, there reasons for despair. But if we're thinking about the relationship between political change and political movement, and the relationship between social movements and legal change, and how far we've come in thinking about political participation, and anticipating where we might be 5, 10, perhaps 15 years down the road, who knows, there's possibility for hope. So I agree with you that we are in a world of deregulation. And the question then becomes, how do we move beyond that and to build that social movement for the purposes of legal change and for the purpose of jurisprudential change?
You mentioned the movement in a number of states to put in place various restrictions, voter ID requirements, limitations on polling places and mail-in voting, and even possibilities for legislatures to override popular vote in some states. Are we seeing any immediate prospects that the courts could intervene and strike down some of these pieces of legislation? The questioner asks whether courts could, for example, require best practices using Section 2.
Yeah, so the Section 2 question, I think, is a great one, because what you have seen with the absence of Section 5 is a lot more pressure placed on Section 2, and presents the possibility, as voting rights activists would say, that, look, Section 2 is still there, and presents some possibility that Section 2 could provide more robust enforcement, and perhaps even the Department of Justice might play a much stronger role in vindicating voting rights. Now, of course, the worry that we have, that one might have, is, in the Brnovich case, is an example of this, is that the more pressure that we place on Section 2, the more pressure then that is placed on its constitutionality. How far will the Supreme Court allow Section 2 to be used, whether it's on statutory or on constitutional grounds? And there, I'm much less optimistic. That is, with a different constitutional composition of the court, one might view Section 2 as providing some robust possibilities. Now, one move may be, what we see a little bit in Congress, with some moderate Republicans, perhaps thinking about the voting rights, race exceptionalism, as an important move. That is to say, look, we're going to defer to the state, but preventing racial discrimination in voting is something that we all have been committed to, that the VRA was bipartisan, had always been for a very long time, and this should still remain a bipartisan framework, and perhaps revitalizing the VRA through a bipartisan approach. I'm a little bit more optimistic about that than I was 6 months ago, right? So that presents one possibility that that might enable or revitalize Section 2, or a different type of a coverage preclearance regime to be effective.
That's one of the questioner's concerns here, that maybe including and emphasizing racial discrimination and racial exceptionalism, as you put it, is really the more politically viable and possibly more judicially viable approach than a more universal strategy. Would you agree with that?
Can you try that one more time, please?
That emphasizing a policy that would really preclude racially targeted discrimination. We can get bipartisan agreement on that. That's more politically viable than getting agreement that really we should have the broad universal
That's
inclusion.
right. I mean, I see the questions from the great Morgan Kauser and the great Brian Landsberg, both of whom are luminaries in this context and make some very sort of these 2 points. Well, Morgan's point is, look, doesn't Gamillion suggest that sort of a targeted race protections for race may be both more politically viable, and then one could argue, and then judicially viable as well, than the non-racial for the people act. And I think as a short-term framework and strategy, that is absolutely right. Right now, the question simply becomes as a long-term matter. So, so if you say, "Hey, we're going to prevent this on the basis of race," and then I say, "Okay, look, this is just a voter ID. It has nothing to do with race." Right? It's and one of the things that we're seeing, for example, that some legislatures are doing now with respect to gerrymandering, they're saying we're not even looking at racial data. We're not looking at racial data at all. We're just engaged in pure political line drawing and structuring our political process. Now, if it so happens to result in, right, but we have nothing to do, we're not at all thinking or using race whatsoever. So this is, again, part of the point that I want to make, that yes, in the short term, we can get agreement. But then eventually we're chasing our tails in terms of the political equality, given the relationship between racial equality and political inequality.
Do you think that ultimately, what is the difference as a practical matter for the outcome of elections for some of these restrictions that at least might at the margins be more discriminatory? How many elections are likely to rise or fall, for example, on some of the restrictions at Georgia and Texas and so forth?
Yeah, that's a great question. This is where, again, I think the epistemic challenges are extremely difficult. So, so you see the voter IDs is a useful example here. The question being, to what extent are voter IDs make it harder for people of color to vote, right? Now, we know from the political science literature that the cumulative effect of voting restrictions certainly matter, and it is hard to gauge the effects of a single and particular set of restrictions. We also know that sometimes there are counter mobilization measures that might dampen the effects of certain types of restrictions. Now, we live in a political environment and context in which a lot of these races and elections are likely to be close. We know that at the presidential level, we could see at least, if even in the context of some of the elections people are going to be watching today, who knows what's going to happen in Virginia and how close that is going to be, right? So in a world that is so politically polarized and almost evenly divided, if the mechanism of political participation is to use tools to make it harder for people to show up to vote as a way of acquiring and maintaining political power, it will have an effect. And then, of course, the hard part is ascertaining when does it have such an effect and how do we make that determination. And part of what I would like to avoid is those whole sets of questions by universalizing measures that we know work to protect and allow people to participate and to engage in the political process.
It may well be that suppressing turnout hurts in some cases Republicans as well. So that's another virtue, it seems to me, of the universalism approach, is that we can just say, let's really get to the core of what democracy is about, which is letting all people have a voice. Speaking of which, I'm going to give to a student the last question here and ask you, what advice would you give young people today who want to join in the fight, join this movement against, as the student questioner puts it, the dog whistle style politics that you mentioned?
Great. That's a great question. Look, I think there are lots of places. So when I was coming out of law school, there were some options available for engaging in democracy building exercises. Today, I think there are so many organizations in every single state. At the state level, there are organizations and entities that are legal. There are ones that are non-legal. There are ones that are partisans. There are ones that are non-partisans. There's so much that is going on in the fight for democracy. What excites me is that these questions are finally on the table. For a moment now, the things that I think and care about are finally relevant. And for students coming out of law school or into law school today, this is a perfect moment to get involved in the fight. So find those organizations, use your legal skills to make the world a better place and leave it a better place for those who are coming behind you. So I want to encourage the students and to let them know that this is a great fight to get involved in.
Well, thank you very much. I might also add, get out and vote today. It is election day.
If you haven't.
And let me apologize to those whose questions I was not able to get to, but thank you all in the audience for joining us today. Most especially, I want to thank Professor Charles for taking the time to be with us today and for giving the Legal Academy and the larger world of election law, policy, and politics so much to aspire toward. That vision of universal inclusion is the vision of the future. Hopefully that future won't be very far away. Thank you very much, Professor Charles. Thank you all for joining us today.